Ms. Catherine Kane, who's Director General and Senior General Counsel, Criminal Law Policy Section, and Mr. Paul Saint-Denis, Senior Counsel of the Criminal Law Policy Section at the Department of Justice Canada. You've both been here before. We're delighted to have you with us again. And I think in this case, I don't think you have opening statements. So I think we'll just go straight to questions. And we will begin with Senator Carignan, followed by Senator Watt and Senator Runciman.
Yes, thank you. I have read the bill, and I know there are some very technical parts to it with the listing of the drugs. I was told about different situations, one of which was the possibility of buying through the internet from outside of the country components for date rape drugs. You can have them sent here by the mail, delivered to you, and you can mix them here to make up a date rape drug. I'm not a chemist, rather. I'm not very knowledgeable in this area, but I would like to know if you're aware of these practices, the fact that there is this possibility of buying the components of a date rape drug on the internet. And can you tell me if the components of these drugs are also included in the universe of importing? Or are the chemicals, do they fall under the importing provisions in the bill? Yes, Senator, it's very clear. We are aware of this type of activity. We know that there are components, ingredients, if you like, that are used to make date rape drugs that can be purchased on the internet. But the provisions of this bill do not target that type of activity, except for the activity of production. The producing is an activity that targets rohypnol, which is the date rape drug. The bill would target that, but not the importing. No, not the actual act of importing the components or the ingredients for it. No. Normally that would be a precursor. And if they are needed precursors that would fall under Schedule 5, if I'm not mistaken, which is outside of the exporting provision. But when you talk about these precursors, you're talking about components, ingredients. Yes. So there is legislation that applies to it. Yes, there are controls with respect to these precursors. But the fact that you produce this type of drug would be targeted, and the mandatory minimums would apply. Thank you, Senator Carignan.
Thank you. I have a question related to young offenders, mainly in the north. Knowing the fact that high cost of transportation is something that everybody don't feel too comfortable with, but the fact is, it's a high cost of transportation that we have to go through. Had the government did any put some what you call the inventory in terms of what are the costs related to this? Have they done the studies in terms of what the cost is? Let's say transporting a person from the north to the south before that person is being thrown into jail. That at least should have an opportunity to go through the what you call what you call those things, correct, to rehabilitations, the treatment centers, knowing the fact there's no treatment existing in the north, and most likely they will not exist for a long time because of the cost. And I'm not sure whether the government have done some feasibility studies in terms by coming up with this bill. What does that mean in terms of the cost, additional cost that government is going to have to bear on the fact that you are dealing with people from far north, and the transportation it's not that easy, because it's, let's say for an example, in my community, 900 air miles, exact 900 air miles, you're talking about over $2,000 return. So who is going to pay for all this? Is the government of Canada is going to pay for those? To bring the people down to get the treatment? I'd like to know what are the strategy, if there is a strategy in place. I'd like to have a clear idea on that.
Senator, I could indicate that the problem you've raised is not unique to drug treatment facilities, but a whole host of issues that present to administer justice in the north. Often people from the north have to be transported to the south for assessments for a variety of purposes because the facilities do not exist in the north. And as time progresses, hopefully there will be more facilities in the north. Some of our colleagues will be appearing tomorrow, and they will be talking about the overall national anti-drug strategy, and they will have some examples based on some information we've gathered from our prosecutors in the north about the existing facilities that do exist in the north already. And some of my colleagues may be able to talk to you about how some of those are funded. There's the Aboriginal Justice Strategy, as was noted by the Minister, and there's also a range of programs that are funded through the youth justice programs in combination with other justice programs. And I can't say for certain which ones fall into the category that you have in mind, but those colleagues will be able to provide some more information on that. And the costs are high when people are moved south. And hopefully, as time progresses, we will see capacity built in the north so that offenders in the north, or accused persons in the north, won't have to be moved to the south for those programs.
Could you, just a supplementary to my questions, just to get a bit more clarifications on this there. Who is, in a sense, have responsibility to cover the cost? Is that the government of Canada, or is that individual person, offender? Who's covering the cost? Who's paying for this?
Well, it will depend on, Senator, it will depend on what exactly is contemplated. If it's the cost of, for example, a person is accused of a crime and they have to be sent to the south for an assessment about their criminal responsibility or their fitness to stand trial, that's an administration of justice.
I'm talking about treatment, accessing a treatment.
That would be at the time of sentencing. If treatment is ordered as part of the sentence, then it will depend on what the type of treatment it is and where it is administered, whether there's an understanding of whether the territory is going to cover the cost or whether it's a cost
okay, let me,
the federal government.
We don't have a whole lot of time with these witnesses. I know it is, so I'm going to ask if you can please provide us in writing a description with some detail of the way the system works, what is available, how much it costs, and who pays.
And also, I'd like to have an idea so I'd be able to compare it, what takes place down south.
Yeah? Fair enough.
Versus the north. I'd like to be able to compare it.
Where are the treatment centers? How, what is the, I don't know if you have these numbers, but if you do, what are the comparative rates of use of treatment centers in the justice system in the north and in the south?
We will provide whatever information we have at our disposal, but the question is very, very broad in terms of the nature of treatment, and it's not going to be possible to say this is the cost for treatment of X or Y. It will depend on exactly what type of treatment. There's no homogeneous treatment program that I think anybody has in mind.
But we have no information at all on this matter in this committee. And it has been for a long time now a concern of this committee always to understand the implications of the bills we pass for all Canadians, but also for Aboriginal Canadians. Therefore, if you can provide us even with ranges or with examples that seem to be, there's no such thing as a typical example of a person in trouble, but you understand what I'm trying to get at. Whatever information you can provide us will be more than useful for us. Okay?
And in addition, I would note that tomorrow colleagues from Health will also be here that might have some information that will elaborate on that issue.
Thank you. Okay, Senator Watt. Senator Runciman, followed by Senators Joyal, Lang, and Baker.
Just a few quick questions. I just wondered what was considered when you were deciding the length of the mandatory minimum sentences. You know, for example, whether it would require incarceration in a provincial institution versus a federal institution. What factors were under consideration there?
The factor that probably weighed the most was concerns over imposing minimum penalties that would fly in the face of the Charter. We had to find ranges that were reasonable and rational and were reasonably connected to the government's objectives. So I think that's the main factor.
Consideration that raises with the minister about the sort of a mandatory delay in parole eligibility that's done in terms of organized crime offenses under the criminal code. Was there any consideration of incorporating that?
No, sir, that was not done. We didn't think of it at all, but given the sort of minimalist minimum penalties that we have, we're not talking about minimum 10 years or things like that. We didn't consider that.
I guess, you know, looking at a provincial institution, 1 year sentence, the likelihood is a good, strong possibility an individual would be released in 4 months or 5 months. Yeah. So, I mean, that's that concerns me with respect to the impact. You know, in terms of the ability to avoid mandatory minimums as well, if an individual is consented to drug treatment, is there a test that you're talking about here? If they simply consent, does that provide that avenue for them? I look at it as possibly a backdoor loophole, but is that there's no other criteria set for that?
For the recourse to treatment? I mean, is your concern that someone wishing to avoid minimum penalties would say, I'm interested in going to? Right. Well, actually the criteria to get into the drug treatment programs is fairly stiff. Individuals who have committed the crime with the use of violence, or if it's for organized crime, or in fact, if most of the factors that are here that were present in the commission of the offense, chances are that they would not be admitted into the drug treatment court program. Now, there are programs under provincial schemes using 720 of the criminal code, where the court may choose to refer the individual, and those programs I can't speak to. But again, given the kinds of minimum penalties that we're talking about of 1 year, 2 years, and those programs tend to be fairly demanding. So I believe that a lot of these offenders would probably choose to do the time because they don't believe that they can adhere to the requirements or the criteria of a successful program. So I'm not sure that many people would resort to choosing the treatment avenue rather than the minimum penalty avenue.